Hello everyone. For today's subject is Sale of Goods Act 1930 and we are going to cover these many topics. It starts from definitions. Definitions cover important terms, legal terms, goods, buyer, seller, price, delivery. Then there are questions in various examinations in the form of short notes. So that we are going to cover contingent goods, future goods, implied warranties, implied conditions, then difference between future goods and contingent goods, difference between sale and agreement to sell, very important. Section 4, it starts from section 4, formation of contract and other things. And then essential elements of contract of sale. These all things are there for movable properties. For goods, then when we take the definition of goods, then we will be knowing about that these provisions are applicable to the movable assets. Then distinguish between conditions and warranties. Implied conditions, implied warranties. When does a condition become warranty? When does a condition become a warranty? What is the doctrine of caveat emptor with exception? Who is an unpaid seller? Rights of an unpaid seller, auction sale, such other things. And the topics which are not covered here are going to be covered in the next session. Definitely. We begin, we start with this.
Hello everyone, welcome to our channel. Sale of Goods Act 1930, important provisions. The act is called the Sale of Goods Act 1930. It extends to the whole of India, and very important thing is the act applies to goods as defined in section 2 subsection 7 of the act, that we are going to see in detail so far as the definition of goods is concerned. Then the principal ingredient is that it is a movable property. The act involves two important elements. One is sale and the second is delivery of movable property. So the focus is on movable property, and here it is sale. One is sale and the second is delivery of movable property. Definitions: buyer, seller, price, goods, delivery. Now, first, very important and simple definition. Buyer, about buyer. Section 2, subsection 1 of the Act defines buyer. A buyer is a person. It says that a buyer is a person who buys or agrees to buy goods. This is about buyer. Next is seller. Section 2, subsection 13 defines seller. Again, it's a simple definition: a person who sells, right? Who sells or agrees to sell goods. Now, next definition is delivery as per section 2, subsection 2. This is voluntary transfer of possession from one person to another person. From A to B, goods, it is voluntarily transferred goods. Voluntary transfer of possession from one person to another. Property as per section 2 subsection 11, property means the general property in goods and not merely a special property. This is about property. What we have seen about the delivery, that is as per section 2 subsection 2, it is voluntary transfer of possession from one person to another. This is very important. Price. Again, very simple definitions. It means the money consideration for sale of goods. Goods, section 2, subsection 7 defines goods as every kind of movable property other than actionable claim and money. It includes the following: stock and shares, then growing crops, grass, and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. This is very important. So far as the definition of goods is concerned. So it says that every kind of movable property other than actionable claim and money, and it includes stock and shares, growing crops, grass and things attached to or forming part of the land, which are agreed to be separated before sale or under a contract of sale. This is about goods. Document of title to goods. Very important definition. Document of title is related to the proof of possession. Proof of possession or control of goods. Whoever is having possession, he will have the proof of having custody of such movables or control of goods. This is very important. As per this definition, under this act, a document of title to goods refers to, means it includes a bill of lading, which is a receipt of shipped material or goods, dock warrant, certificate of warehouse keepers or finger certificates, railway receipt, multi-modal transport document, warrant or order for the delivery of goods. It also includes any other document used in the ordinary course of business as a proof of possession of control of goods or authorizing or purporting to authorize either by endorsement or by delivery the possessor of the property to transfer or receive goods thereby represent. This is about the definition. What is more important is that document of title is related to the proof of possession. Here we have seen proof of possession or control of goods. This is very important and it includes these many things: bill of lading, dock warrant, certificate of housekeepers, a certificate of warehouse keeper, wash finger certificates, railway receipts, etc. Future goods. What is the meaning of future goods? Subsection 6 of section 2 defines future goods. Goods are to be manufactured. Goods to be manufactured or produced or acquired by the seller after making of the contract of sale. Means today contract is executed, but it is about the goods to be manufactured. Goods to be manufactured. This is very important. Goods to be produced or goods to be acquired by the seller. Means seller is not having goods in custody today. He is not having goods ready, but is likely to manufacture it after making of the contract of sale. Therefore, it is called future goods. Example is here. A agrees to sell all the mangoes which will be produced in his garden next season. This is an agreement for sale of future goods. Next is specific goods. Subsection 14 of section 2 defines it as goods identified and agreed upon at the time of contract of sale. Such goods are identified at the moment of sale. This is very important so far as specific goods is concerned. And existing goods, one small thing is there here. Very important aspect about existing goods is that which are either owned at the time of contract. Okay. Now here we see these are the at the time of goods which are either owned or possessed by the seller at the time of the contract. Therefore, these are called existing goods. Contingent goods, where there is a contract for the sale of goods. Where there is a contract for sale of goods. Contract is already there for sale of goods. The acquisition of which by the seller depends upon a contingency which may or may not happen. Such goods are known as contingent goods. Such type of goods fall in the class of future goods. So contingent goods. These are the things which we have seen so far as definitions are concerned. Now we see another important topic. That topic is regarding formation of contract. How this contract is formed. Formation of contract. And then section 4 says the sale and agreement to sell. What is sale and what is agreement to sell? In case of sale, it says that in case of sale, the property in the goods sold passes to the buyer at the time of contract so that he becomes the owner of the goods. If the contract is between A and B, then in that case, sale becomes absolute. It means the property in the goods is transferred to B by A. If A is the seller and he intends to sell this property in the goods to B, then at the time of contract itself, it becomes sale. In the case of an agreement to sell, the ownership does not, this is very important, does not pass to the buyer at the time of contract. However, it passes only when it becomes sale on the expiry of certain time, on the expiry of certain time or the fulfillment of some conditions subject to which the property in the goods is to be transferred. This is one of the things. This is first thing we are seeing so far as sale and agreement to sell difference is concerned. What is sale and what is an agreement to sell? Another thing is that a sale is an executed contract, whereas an agreement to sell is an executory contract, not fully performed. It is not fully performed. A sale is a contract plus conveyance, whereas an agreement is a simple contract. In the matter of an agreement to sell, if the goods are destroyed by accident, the loss falls on the seller. Whereas in case of sale, the loss falls on the buyer even though the goods are with the seller, because ownership is transferred in case of sale. That is what here we have seen, that property in the goods sold passes to the buyer. Therefore, the even though goods are with the seller, the loss falls on the buyer. If there is an agreement to sell, the seller commits a breach, the buyer has only a personal remedy against the seller, namely claim for damages. If there has been a sale, if sale is there, then the seller commits breach by refusing to deliver the goods themselves, such as suit for conversion or detinue, etc. The buyer has a personal remedy against him, and also the other remedies which an owner has in respect of goods. This is about formation of contract. Now formalities of contract. Section 5, that we are going to see. Formalities of contract. Formalities of contract of sale, how it is made. That we are going to see now. A contract of sale of goods is a contract by way of which the seller offers to transfer the property in goods to the buyer for a price that is a consideration and it is accepted by the buyer. This is how contract of sale of goods is made. As per section 5 of the Sale of Goods Act, a contract of sale of goods is a contract by way of which the seller, the person who intends to sell, offers to transfer the property in goods to the buyer for a consideration. and it is accepted by the buyer. This is how a contract of sale of goods is made. The term contract of sale covers both a sale and an agreement to sell. That is to say, where the seller transfers the ownership of the goods to the buyer, and an agreement to sell where the ownership of goods is to be transferred at a future time. This is future time or subject to some condition to be fulfilled later on. This is about to be transferred at a future date. Here, in the first case, where the seller transfers the ownership in case of sell, and in the case of an agreement to sell, the ownership of goods is to be transferred at a future date or future time, subject to some conditions to be fulfilled. In other words, a contract of sale is made by an offer to buy or sell goods for price and the acceptance of such offer. Sorry. Such contract may provide for immediate payment of the price or delivery of goods, or both, or the delivery of payment by installments, or that the delivery of payment or both shall be postponed. Essential elements of कॉन्ट्रैक्ट ऑफ सेल ऑफ गुड्स. एसेंशियल एलिमेंट्स इसके क्या है वो अभी हम देखते हैं. बायलैटरल कॉन्ट्रैक्ट. It is a contract between two parties because the property in goods has to pass from one party to another. A person cannot buy goods himself. So it is a contract between two parties whereby the property in goods is going to be transferred, going to be passed from one party to another party. Then second essential element is that transfer of property. The object of a contract of sale must be the transfer of property, meaning ownership in goods from one person to another. So, this is transfer of property from one person to another. The subject matter must be some goods. Price or money consideration. The goods must be sold for some price, whether the goods are exchanged for goods, it is barter, not so. All essential elements of valid contract must be present in contract of sale. These are the essentials of contract of sale of goods. Subject matter of contract. We move to next topic, and it is existing or future goods. Section 6 of the Act deals with the existing or future goods. The goods which form the subject matter of a contract of sale may be either existing goods owned or possessed by the seller, or future goods. There may be a contract for the sale of goods to acquire such goods by the seller in future, depending upon the contingency which may or may not happen. So this is what we are seeing now. What we have seen is that existing or future goods. Section 6 of the Act deals with existing or future goods. The goods which form the subject matter of a contract of sale may be either existing goods owned or possessed by the seller, or future goods. There may be a contract for the sale of goods to acquire such goods by the seller in future, depending upon a contingency which may or may not happen. Now, we see the example. X agrees to sell a laptop provided he is able to get it from its present owner. This is an agreement to sell this is an agreement to sell contingent goods. In such a case, if the contingency does not happen for no fault of the seller, he will not be liable for damages. This is what we have seen about the so far as part B is concerned. There may be a contract for the sale of goods to acquire such goods by the seller in future, depending upon a contingency which may or may not happen. And here is an example. Effect of perishing of goods. In a contract of sale of goods, the goods may perish before sale is complete. Such a stage may arise in the following cases: goods perishing before making a contract. Very important thing here. Just maybe it is. Yes, before making a contract. Where a contract of sale of specific goods, the goods without the knowledge of the seller have, at the time of making the contract, perished or become so damaged as no longer to answer to their description in the contract is void. Because it happens before making a contract. The goods without the knowledge of the seller have at the time of making the contract perished or become so damaged as no longer to answer to their description in the contract. The contract is void. This is based on the rule that mutual mistake of fact essential to the contract renders the contract void because the seller was not aware of it, buyer was not aware of it. If the seller was aware of the destruction or still entered into the contract, he is stopped from disputing the contract. Moreover, perishing of goods not only includes loss by theft but also where the goods have lost their commercial value. Goods perishing after agreement to sell. We saw before agreement to sell, now we are seeing after agreement to sell. Where there is an agreement to sell goods, specific goods, and subsequently the goods without any fault of any party perish or so damaged as no longer to answer to their description in the agreement before the risk passes to the buyer, the agreement is therefore avoided. The provision applies only to sale of specific goods. If the sale is of uncertain goods, the perishing of the whole quantity of such goods in the possession of the seller will not relieve him of his obligation to deliver. This is provided under section 8. That is what goods perishing after agreement to sell is there. Conditions and warranties, very important part that we are going to see in detail. While conducting a contract of सेल, कोई भी कॉन्ट्रैक्ट ऑफ सेल जब होता है, certain statements are made by the parties, right? Certain statements are made. That is the basis actually. So in so many cases, the basis of contract is because they make a statement. They make statements, different kinds of statements. The statement may amount to a stipulation forming part of the contract or mere expression of opinion which is not part of the contract. If it is a statement by the seller on the reliance of which the buyer makes the contract, it will amount to a stipulation. Material condition हो जाएगा. Stipulation means material condition. If it is a statement by the seller on the reliance of which this buyer makes a contract, means buyer relies on such statement and enters into contract, then it will amount to a stipulation. It will amount to condition, material condition. Oh, that we are going to see. If it is a mere commendation by the seller of his goods, it does not amount to stipulation and does not give him the right of action. The stipulation may either be a condition or a warranty. Now, section 12 draws a clear distinction between a condition and a warranty. Whether a stipulation is a condition or only a warranty is a matter of substance rather than the form of words used. A stipulation may be a condition, though called a warranty, and vice versa. How? We are going to see. Condition. We start first condition. if the stipulations form the very basis of the contract or is essential to the main purpose of the contract, it is a condition. If the stipulation forms the very basis of the contract, this is very important actually, so far as the conditions part is concerned. Okay. The breach of the condition gives the aggrieved party a right to treat the contract as repudiated, cancelled. Thus, if the seller fails to fulfill a condition, the buyer may treat the contract as cancelled, terminated, refuse the goods, can refuse to accept the goods, and if he does, if he has already paid for them, recover the price. He can also claim damages for the breach of contract. दिस इज वेरी इंपॉर्टेंट सो फar एज कंडीशन पार्ट इज कंसर्न, ये हमको जान लेना चाहिए कंडीशन के बारे में। ये मटेरियल कंडीशन जो होती है, द रिलायंस इज प्लेस्ड ऑन दैट ओनली, that if that condition is not fulfilled, whatever is there, that statement made by the seller is not fulfilled, because based on that statement only the contract was executed. Now warranties, जहाँ तक वारंटी की बात है, if the stipulation is collateral to the main purpose of the contract, it is collateral to the main purpose of the contract, is a subsidiary promise, it is a warranty. If the seller does not fulfill a warranty, the buyer must accept the goods and claim damages for breach of warranty. It means the effect of breach of warranty is that the aggrieved party cannot repudiate the contract but can only claim damages. They can claim damages. In some cases, a condition seeks or descends to the level of a warranty. The first two cases depend upon the will of the buyer, but the third is compulsory and acts as estoppel against it. A condition will become a warranty when the buyer waives the condition. He himself waives the condition. A condition will sink to the level of warranty where the buyer treats the breach of condition as a breach of warranty. And the third is where the contract is indivisible and the buyer has accepted the goods or part thereof. The breach of condition can only be treated as a breach of warranty. This is where the buyer can only claim damages and cannot reject goods or treat the contract as repudiated. Doctrine of Caveat Emptor. It is a Latin word, it means let the buyer be aware. This principle clarifies that it is for the buyer to satisfy himself that the goods which he is purchasing are of the quality which he requires. Means he has to ensure that buyer needs to ensure that what he needs to ensure that that to satisfy himself that the goods which he is purchasing are of the same quality which he wants to purchase. This is so far as this doctrine is concerned. He buys goods for a particular purpose. He must satisfy himself that they are fit for that purpose. That is about caveat emptor. The doctrine of caveat emptor is embodied in section 16 of the Act, which state that subject to the provisions of this Act and of any other law for the time being in force, there is no implied warranty or condition as to the quality or fitness for any particular purpose or goods supplied under a contract of sale. Subject to the provision of this Act and of any other law for the time being, there is no implied warranty or condition as to the quality or fitness for any particular purpose of goods supplied under a contract of sale. This is what about section 16. In simple words, it is not the seller's duty to give to the buyer the goods which are fit for a suitable purpose of the buyer. If he makes a wrong selection, if buyer makes a wrong selection, buyer cannot blame the seller if the goods turn out to be defective or do not serve his purpose. This is the meaning of this doctrine. Exceptions to this doctrine, section 16 lays down the following exceptions to the doctrine of caveat emptor, where the seller makes a false representation and the buyer relies on it. Seller is giving misleading information and buyer relied on that and executed the contract or purchased the goods. When the seller actively conceals a defect in the goods which is not visible on a reasonable examination. Reasonable examination, yes, he could see that, but he could not go into the so far as the product's description is concerned, details are concerned. So whether this when the seller actively conceals a defect in the goods, which is not visible on a reasonable examination, he could not see it, so he can always get. The third exception is when the buyer, relying upon the skill and judgment of the seller, has expressly or impliedly communicated to him the purpose for which the goods are required. Supposing for trekking purpose he needs cycle or some sort of instruments, which he already buyer already gave the description, but the seller failed to provide him the goods of the same quality. So therefore, this exception applies. In the fourth case, if the buyer examines a sample before buying his goods, then this doctrine will not apply. In case the rest of the goods do not match or resemble the sample, the seller can be held responsible for not delivering the goods of the same quality as per sample. This is an exception to the doctrine of caveat emptor. Now we see the performance of the contract of sale, duties of seller and buyer, section 31 and section 32, important sections with regard to performance of the contract of sale, duties of seller and buyer. It is the duty of the seller and buyer that the contract is performed. The duty of the seller is to deliver the goods, and that of buyer is to accept the goods and pay for them in accordance with the contract of sale. Unless the parties agree otherwise, payment of price and the delivery of the goods are concurrent conditions. They both take place at the same time as in cash sale or a shop counter. This is very important with regard to performance of the contract of sale. बायर की ड्यूटी है, सेलर की ड्यूटी है. सेलर की ड्यूटी है, what is the duty of the seller? The seller is bound to deliver the goods and the buyer is bound to accept the goods and pay for taking the goods, buying the goods. These are the concurrent conditions. They both can take place at the same time, as in the case of we see usually at shop counter. Delivery, section 33 to 39, very important sections that we are going to see. Very important about this delivery part. Delivery is the voluntary transfer of possession from one person to another. Now this voluntary word has come, it has got meaning. Voluntary transfer of possession from one person to another. How that works? It may be actual, constructive, or symbolic. Actual or physical delivery take place where the goods are handed over by the seller to the buyer or his agent authorized to take possession of the goods. This is actual possession. How it happens? Actual or physical delivery takes place when the goods are handed over by the seller to the buyer or his agent authorized to take possession of the goods. Handed over by the seller to the buyer. This is called actual or physical delivery. Constructive delivery takes place when the person in possession of the goods acknowledges that he holds the goods He is holding the goods on behalf or at the disposal of the buyer. He represents the buyer actually. He is saying that yes, he holds the goods for on behalf of the buyer. As per buyer's instructions, he will deal with the goods. This is about constructive delivery. And here we have seen when it is handed over by the seller to the buyer, the goods are handed over by the seller to the buyer, then it is actual or physical delivery that takes place. Example, where the seller, after having sold the goods, may hold them as belly for the buyer. There is constructive delivery. Symbolic delivery is made by indicating or giving a symbol. Here, the goods themselves are not delivered, but the means of obtaining possession of goods is delivered. That is, by delivering the key of warehouse where goods are stored, bill of lading, which will entitle the holder to receive the goods on the arrival of the ship. This is what symbolic delivery. Rules as to delivery, that we can see the following rules apply regarding delivery of goods. Delivery should have the effect of putting the buyer in possession. Yes, very important it is. What is the purpose? Otherwise there is no purpose of delivering the goods. Delivery should have the effect of putting the buyer in possession. The seller must deliver the goods according to the contract. That is what we have seen earlier also. He is bound to give it as per terms of contract. The seller is to deliver the goods when the buyer applies for delivery. It is the duty of the buyer to claim delivery. If he doesn't do it, then he's waiving his right. Then that is up to him. Where the goods at the time of the sale are in the possession of a third person, there will be delivery only when that person acknowledges acknowledges to the buyer that he holds the goods on his behalf. This is how the delivery happens. The seller should tender delivery so that the buyer can take the goods. It is very important. The seller should render delivery so that the buyer can take the goods. It is no duty of the seller to send or carry the goods to the buyer unless the contract so provides. But the goods must be in a deliverable state at the time of delivery or tender of delivery. If the contract, if by the contract the seller is bound to send the goods to the buyer, but no time is fixed, the seller is bound to send them within a reasonable time. Within a reasonable time. This is about all these things are about rules as to delivery of goods. The place of delivery is usually stated in the contract. It is mentioned in the contract. Where it is stated the goods must be delivered at a specified place during working hours on a working day. Where no place is mentioned, the goods are to be delivered at a place at which they happen to be at the time of the contract of sale. And if not, then in existence they are to be delivered at the place at which they are manufactured or produced. The seller has to incur the cost of delivery unless the contract otherwise provides. While the cost of obtaining delivery is said to be of the buyer, the cost of putting the goods into deliverable state must be borne by the seller. In other words, in the absence of an agreement to the contrary, the expenses of an incidental to making delivery of goods must be borne by the seller. These expenses of an incidental to receiving delivery must be borne by the buyer. If the goods are to be delivered at a place other than where they are, the risk of deterioration in transit will unless otherwise agreed, be borne by the buyer. Unless otherwise agreed, the buyer is not bound to accept delivery in installment. Acceptance of goods by the buyer. Very important. Acceptance of the goods by the buyer takes place when the buyer intimates to the seller that he has accepted the goods or retains the goods after the lapse of a reasonable time without intimating to the seller that he has rejected them, and does not act on the goods which is inconsistent with the ownership of the seller, that is pledges or receipts. Intimate to the seller that he has accepted the goods. Acceptance of goods कब होता है? Acceptance of the goods by the buyer takes place when he intimates, okay, he retains, even if he does not intimate, but he retains the good, he retains the goods after the lapse of a reasonable time without intimating to the seller that he has rejected them. Even if he wants to reject, but he retains it for reasonable time, and sees does not act on the goods which is inconsistent with the ownership of the seller, that is pledges or resales. If the seller sends the buyer a large or smaller quantity of goods than ordered, the buyer may reject the whole, accept the whole, or accept the quantity ordered and reject the rest. Seller of goods is deemed to be unpaid seller when the whole of the price has not been paid or tendered to him. When the whole of the price has not been paid or tendered to him, or a conditional payment was made by way of negotiable instruments, and such negotiable instruments have been dishonored or returned unpaid. So certain instruments like checks or bill of exchange were issued, but the payment was not made under such instruments. Similarly, here the whole of the price has not been paid or tendered to him. So therefore, the seller is called as unpaid seller. This definition is very important. Who is an unpaid seller? The seller of goods is deemed to be an unpaid seller when the whole of the price has not been paid to him or a conditional payment was made by way of negotiable instrument, and such negotiable instrument has been dishonored or returned unpaid. Rights of unpaid seller against the goods, right of lien. Then an unpaid seller in possession of goods sold, in possession of goods sold, may exercise his lien on the goods, that is keep the goods in his possession and refuse to deliver them to the buyer until the fulfillment or tender of the price in cases where the goods have been sold without stipulation as to credit, or the goods have been sold the goods have been sold on credit, but the term of credit has expired or the buyer becomes insolvent. The lien depends on physical possession of the goods. The seller, now the seller's lien is possessory lien, so that it can be exercised only so long as the seller is in possession of the goods. That is very important. It can only be exercised for the non-payment of the price and not for any other charges. A lien is lost. Under what circumstances the unpaid seller is going to lose his right of lien? When the seller delivers the goods to a carrier or other bailey the bailey for the purpose of transmission to the buyer without reserving the right of disposal of the goods. When the buyer or his agent lawfully obtains possession of the goods by waiver of his lien by the unpaid seller. These are the circumstances in which a lien is lost. When the seller delivers the goods to a carrier or other bailee for the purpose of transmission to the buyer without reserving the right of disposal of goods, where the buyer or his agent lawfully obtains possession or by waiver of his lien by the unpaid seller. Stoppage in transit. 50, section 50 to 52. The right of stoppage in transit is a right of stopping the goods while they are in transit, resuming possession of them and returning possession and retaining possession until payment of the price. This is what stoppage in transit. The right to stop goods is available to an unpaid seller when the buyer becomes insolvent and the goods are in transit. The right to stop goods is available to an unpaid seller when the buyer becomes insolvent and the goods are in transit. Now, the buyer is insolvent if he has ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due. It is not necessary that he has actually been declared insolvent. The goods are in transit from the time when they are delivered to a carrier or other bailee, like a wharfinger or a warehouse keeper, for the purpose of transmission to the buyer and until the buyer takes delivery of them. Transit comes to an end in the following cases. Transit comes to an end. The transit. If the buyer obtains delivery before the arrival of the goods at their destinations. If after the arrival of the goods at their destination, the carrier acknowledges to the buyer that he holds the goods on his behalf, even if further destination of the goods is indicated by the buyer, if the carrier wrongfully refuses to deliver the goods to the buyer. There, in this case, the transit comes. Suit for breach of contract, section 55 to 57 of sales of suits for breach of contract. The seller may sue him for the price where the property in the goods has passed to the buyer and the buyer wrongfully neglects or refuses to pay. If the buyer wrongfully neglects or refuses to pay for the goods, so therefore the seller has got right to proceed against him for recovery of the price amount, where the price is payable on certain day regardless of delivery. The seller may sue for the price if it is not paid on that day, although the property in the goods has not passed. And third, the seller may sue the buyer for damages for non acceptance, where the buyer wrongfully neglects or refuses to accept the goods and pay for them. So, in this case, what he did, he is not paying, he has received it, but he has not paid it. In this case, regardless of the delivery, what happened, he agreed to pay on a particular day or the specified time, whatever is there on a certain day, but he failed to pay. And in the third scenario, the seller may sue the buyer for damages for non acceptance, where the buyer wrongfully neglects or refuses to accept the goods and pay for them. This is what about the seller's right. The buyer's right, so far, the buyer may sue him for damages for non delivery, where the seller wrongfully neglects or refuses to deliver the goods to the buyer. Okay, so the buyer has also got remedy here. The buyer can sue the seller for the recovery of the amount paid if the buyer has paid the price and the goods are not delivered. This is what the buyers know about the buyers we are seeing. So far as the buyer's rights are concerned, why he is not given the, so far as the goods have not been delivered to him, or if the buyer has paid the price and goods are not delivered, And in the first case, he refused to deliver. In the second case, the buyer may, in the first case, what is there? The buyer may sue him for damages for non delivery. And in the second case, the buyer can sue the seller for recovery of the amount paid. He has paid here, so the buyer has paid the price and the goods are not delivered. Therefore, buyer can sue the seller. And this is the third thing where there is a breach of warranty or where the buyer elects or is compelled to treat the breach of condition as breach of warranty. The buyer cannot reject the goods. This is about so far as suits for breach of contract. Who can bring the who can file suit for breach of contract? Seller in certain cases, buyer in certain cases. Now we see next topic is auction sales. Section 64 of the Sale of Goods Act provides for rules of auction sale. It is a proceeding at which the seller invites people to compete for the purchase of goods or property by participating in the auction proceedings. A sale by auction is a public sale. In auction sale, the goods offered to be taken by bidders, and the highest bidder is uh, the highest bidder becomes the purchaser. The present section provides the rules regulating auction sales where goods are put up for sale in lots, and each lot is considered to be the subject of a separate contract of sale. Now, the sale transaction becomes complete. When it becomes complete? When the person holding the auction declares its completion by the fall of the hammer or in other customary manner. Until such announcement is made by the auctioneer, any bidder may retract his bid. A right to bid may be reserved expressly by or on behalf of the seller. Where such a right is expressly so reserved, the seller or any person on his behalf may bid at the auction. But if it is not there, if the right is not reserved, then he cannot participate in the bid. This is what it says. And any sale in contravention of this rule may be treated as fraudulent by the buyer. The sale may be notified to be subject to a reserve price. Now, now some questions. When does a condition become a warranty? A breach of condition can be treated as a breach of warranty in the following cases. Discretion of buyer. The buyer can waive the condition or elect to treat the condition as a warranty and claim damages instead of cancelling the contract. The buyer accepts the goods where the contract of sale is not divisible and the buyer has accepted the goods. The breach of the condition can only be treated as a breach of warranty. These two things we have seen. Now next example, A ordered particular brand wheat 10 kg at 55 per kg to B delivered 10 kg of wheat of some other brand at rupees 55 per kg. In this case, the contract would have been cancelled by A, but he, due to urgency, accepted wheat of other branch instead of sure wheat and claimed damages from Mr. B. This is about the so far as when does a condition become a warranty. So discretion of buyer when buyer decides, and in the second matters also when buyer accepts the goods. In the first case, it is the discretion of the buyer. Buyer waive the condition. In the second case, due to some reason and where the contract of sale is not divisible and the buyer has accepted the goods, the breach of condition can be treated as breach of warranty. Now we see the implied warranties. Short note: we just see in a contract of sale, the implied warranties are as follows. What are the warranties are there? The warranties are like peaceful possession of goods, then goods should be free of charge, good quality of goods, and revelation of dangerous types of goods. These four things are very important, and these are the implied warranties in the contract of sale of goods. This is the warranty. Peaceful possession. This is the warranty that the buyer should be having and enjoying peaceful possession of the goods. That means if he is giving it to the seller, then if the seller is having this type of peaceful possession, then he can give it to the buyer, and therefore the buyer should be having and enjoying peaceful possession of the goods after purchase of the goods. It should be free of charge. There should not be any kind of encumbrances, no encumbrance of any kind. There is no hypothecation, nothing is there. The goods shall be free from any charge in favor of third party. And good quality, and implied warranty or condition as to quality, fitness, suitability for specific goods is expected, required. This is what is very much essential when the seller is going to sell his goods. And if any things are there which are of precautions have to be taken, or certain types of dangerous types of goods are there, if goods are not safe for use, the seller clearly specifies, the seller should specify this fact to buyer to avoid future liability or claim against the seller, because he can claim damages tomorrow after he gets to know. So it is the duty of the seller to reveal, to disclose the dangerous types of nature of goods if he is selling it. This is about the short notes so far, and we have covered many question answers in this session. The intention is that we cover maximum question answers, and further also on this part 2 we are going to cover maximum question answers on Sale of Goods Act 1930. Thank you so much.